Afternoon in State of Ohio versus Joseph Melenda, case number 25 CR 362. Your Honor, the defendant has previously pled guilty to 7 counts of gross sexual imposition, all in violation of Ohio Revised Code 2907.05A5. They are all felonies of the 4th degree. Your Honor, Mr. Melenda is present. He is in the courtroom today, represented by counsel Mr. Mark Ziccarelli and Mr. Matthew Ziccarelli. Your Honor, prior to today's hearing, a pre-sentence report and a psychological evaluation were ordered, and they have been completed. The state has had the opportunity to review those reports, and the state is prepared to proceed with sentencing here today. For the record, Your Honor, the defendant has credit for 237 days of jail as of today. Thank you.
Thank you. Mr. Ziccarelli, any reason not to go forward with sentencing at this time?
No, Your Honor.
What we're going to do first before actually proceed to the sentencing hearing, though, is I'm going to advise Mr. Melenda of what his obligations and duties will be to register upon release from any incarceration. As I explained to you at the time of the plea, Mr. Melenda, in as much as you pled guilty to a sexually oriented offense, you'll be required to register as a sex offender once you're released from incarceration. And I'm required at this point at the sentencing hearing to advise you specifically as to what those responsibilities and duties will be. So I'm going to do that this time. I'm going to read you this form. I'm not expecting you to memorize it. You'll get a copy of this when we're done. But I'm required to do that at this time. At the very end, I'm going to ask you to sign this document. Your signature is simply acknowledging that I read it to you and you understand it. It doesn't necessarily mean you have to agree with what I'm telling you or agree that's what the law requires, but you're acknowledging that I read the requirements to you and you understand them. If you have any questions, make sure you ask, all right?
Yes, Your Honor.
All right, let me just make sure some basic information. Your social security number is 699-010240.
Yes, Your Honor.
At this point, your expected residence address upon release from any incarceration will be the Men on the Lake address on Springwood Drive,
Yes, Your Honor.
5917.
Yes, Your Honor.
And phone number 574-304-0687. All right, well, you have pled guilty to a sexually oriented offense as defined in the revised code, section 2950-01, and you are hereby classified as a tier 1 sex offender. You will be required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if you were temporarily domiciled for more than 3 days. You're also required to register in person with the sheriff of the county in which you establish a place of education, if that's applicable. You're to do that immediately upon coming into that county, if it's a different county. If you establish a place of education in another state but maintain a residence or temporary domicile here in Ohio, you will also be required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You will also be required to register in person with the sheriff of the county in which you establish a place of employment if you've been employed for more than 3 days or for an aggregate or total of 14 days in a calendar year. Again, that's if it's a different county than the one you're residing in. If you establish a place of employment in another state but maintain a residence or temporary domicile here in Ohio, you are also required to register in person with the sheriff or other appropriate official in that other state if you have been employed for more than 3 days or for an aggregate or overall total of 14 days in any calendar year. Employment does include volunteer services. Now, you are required to provide to the sheriff temporary lodging information, including address and length of stay, if your absence will be for 7 days or more. After the date of your initial registration, you will be required to periodically verify your residence address, your place of employment, and your place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change residence address, place of employment, and or place of education, you shall provide written notice of that change to the sheriff with whom you most recently registered and to the sheriff in the county in which you intend to reside or establish a place of employment and or place of education at least 20 days prior to any change and no later than 3 days after change of employment. If the residence address change is not to a fixed address, you shall include a detailed description of the place or places you intend to stay, and no later than the end of the first business day immediately following the day you obtain a fixed address, you must register with the sheriff that fixed address. Now, you are further advised, in accordance with federal law, that you must report any international travel, if that's applicable, to your registering authority no less than 21 days before travel. Failure to do so may subject you to criminal prosecution. You shall provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers registered to you or used by you to the sheriff with whom you most recently have registered. Now, you will be required to comply with all of the above described requirements for a period of 15 years, that being for what the requirement is for a Tier 1 offender, and you must do that in person annually, meaning once a year. Now, since your expected residence address at this time, as stated above, is in Lake County, Ohio, you will be required to register in person no later than 3 days after release from any incarceration with the County Sheriff's Office here in Lake County, located at 84 State Street in Painesville, Ohio, 44077. Now, again, if that's not where you're going to be residing, if it's going to be in a different county, then obviously that address is irrelevant, and you have to determine the appropriate place to register if it's a different county. But this is the address for Lake County at this point. Now, your failure to register, failure to verify residence at the specified times, or failure to provide notice of change in residence address or other required information as described above will result in additional criminal prosecution. You understand that?
Yes, Your Honor.
All right. Do you have any questions for me regarding these responsibilities or these duties you're going to have to register upon your release?
Your Honor.
You understand them all?
Yes, Your Honor.
All right, then I'm going to hand you this form now. My bailiff will hand it to you. And on line 11 it reads, I acknowledge that the above requirements have been explained to me and that I must abide by all the provisions of the Ohio Revised Code, Chapter 2950. That's the chapter in the Revised Code that sets forth this all. I'm going to ask that you place your signature and date. Again, it's simply acknowledging that I read it to you and you explain it. And you understand it. All right, you signed the document here, Mr. Melinda?
Yes, Your Honor.
All right, I'm going to place my signature now on line 12, which says that I certify, specifically inform the offender of his duties as set forth above, and he indicated to me an understanding of those duties. Place my signature there at this time. So, Mr. Shadow, if you can make, at least 4 copies of this document, and then we'll pass them out at the conclusion of the hearing. All right, Mr. Ziccarelli, then, you said there's no other reason to not go forward with sentencing?
No, Your Honor. Thank you.
Is there anything you'd like to say on behalf of your client then at this time?
Thank you, Your Honor. I would. Joseph Melendez here stands before you for sentencing today. As the prosecutors indicated, he has pled guilty to 7 counts of gross sexual imposition. Those are felony 4s. He and I have had a conversation, and he understands that this court has the ability to sentence him from 6 months on a monthly increment, anywhere up to 18 months on each of those counts. As the prosecutors indicated, he's had a psychological evaluation, pre-sentence report. He understands that this court has to balance punishing him and protecting the public from further crime, and that you have to look at the seriousness of his conduct on his sister and consistent with sentences for similar crimes by similar offenders. As this court is aware from prior conversations, his twin brother Luke was recently sentenced by Judge Condon to a term of imprisonment of 84 months or 7 years. We believe that Joseph's case is different than his brother's and that a lesser sentence is appropriate. Joseph is 20, just had a birthday in June of this year. Before these incidents occurred with his sister, it was his intent to enter the priesthood. Unlike many young people that you see in this case, in this court, he's never had alcohol or drug issues. The only alcohol he ever had was the communion wine at church. He's never had any sort of that. And as the court is aware, I don't know if ultra-strict Catholic faith would be the right word, but he grew up in a very restrictive, ultra-conservative household. This side of him was did a lot of things that were very good. He was involved in sports. He did baseball. He did lacrosse. He did soccer. He was also very involved in his community. Became part of the Civil Air Patrol. When his dad took he and his brother to North Carolina, he continued and he registered, took a written test. North Dakota, I'm sorry. Took a written test and was part of that. He was involved with the Knights of Columbus. When he was young, he used to clean the tables and do that type of stuff. And as he grew older, he would be at the fish fries, help cook the meals every Friday. He would be at the pancake breakfast that they had once a month. He would go on the Right to Life marches. He collected food for the poor, helped distribute that to the community. He was also involved with St. Vincent de Paul, helped sort clothes for the needy. He also had a work history. When he was 16, he started washing dishes at a pizza parlor. He worked at Regal Cinema in Willoughby for about a year. When he went to North Dakota with his dad and brother, he worked again in the movie theater, but he also worked as a ramp agent at an airport out there, having two jobs at the same time. As this court's aware, he has no prior juvenile history, no prior criminal history. Now, the other side of the equation, his parents had financial issues. Joseph moved 16 times before finally coming back to Men on the Lake in 2023. He had to change schools on all of those moves. He was homeschooled from kindergarten through 4th grade, 6th and 11th grade, but graduated from Menor High with over a 3.0. Now, against this backdrop of all the good things, being raised in this strict environment, when he was 10 or 11, he had the talk. He had the talk of growing up with his dad. And you have to look at Joseph in this light rather than in the reasonable man light, because this wasn't a reasonable household. And when he had the talk with his dad, he was told that masturbation was a sin, that you would go to hell. And his dad, as we know, is a convicted sex offender. His dad was, he didn't actually abuse Joseph, but there were certainly indications that he was inappropriate, did inappropriate things. But again, you're a young boy, and you listen to what your dad says. He tells you that masturbation's a sin, you're going to go to hell, you're very Catholic. And this isn't a justification, this doesn't excuse what he did. But again, it is, as I've indicated to the court, this is a lot like 18-year-old Damon Lundgren, which did bad things, but you grow up for so many years, you believe what your father tells you is right. You believe that you should listen to your father. You should believe that your father's all-knowing. Isn't that right? That you should believe all of those things. And that's what he grew up with. And he was told that he couldn't date till he went to college. He was restricted on the internet. Now all of a sudden, Joseph turns 13 right around that time, and he's in school. And now he's hearing from some of his friends about sex. And Dad says, don't masturbate, don't release that, don't date. So he does something that he shouldn't be doing, and he sexually touches his sister. He fondles her, and the court has read the report, and he admits that he fondles her, and at that time he's very socially immature. He finally, when they come to Ohio, He's investigated. He makes a complete statement to the police. He never denies his involvement. I believe he's remorseful. If you read his pre-sentence report, he now knows his actions were horrible, and he had no good reason for doing it. He loves his sister. He knows his sister loves him. In fact, his sister doesn't want him to go and spend a long time in prison for this. In his pre-sentence report, he says, "I know in my heart and mind that my actions were unlawful and sinful." The prosecutor would indicate to the court that he's very truthful, more truthful than his brother. He's indicated he's mentally prepared to serve whatever sentence the court finds necessary for his actions, and he hopes to earn the forgiveness of his sister, family, and friends. He understands that he needs to be punished, but again, we are suggesting that his background, although not a justification, certainly had an impact on the actions that he did. In looking at section 292912C, recidivism is less likely. He has no delinquency record, no criminal record. These are circumstances that will not reoccur, and I believe that he has genuine remorse. As the psychological evaluation indicated, he struggles mentally with age-appropriate decisions, but is very clear on understanding that what he did was wrong. We would ask, Your Honor, that this court sentence him to a lesser sentence than his brother, based on him being more forthcoming, more honest and truthful, and we believe more remorseful. We would ask that the court, respectfully ask the court to consider a term of imprisonment of 4.5 years with credit for 237 days.
Thank you. Mr. Melenda, you have the right to address this court before you are sentenced. You can say anything you would like. Is there anything you would like to say at this time?
Yes, Your Honor. My lawyer did a great job defending me, so I'm very thankful for him, but as he stated, I'm very sorry for my actions. I have no good reason for why I did them. I'm just sorry. I'm hoping that when I'm released, that I can do whatever probation requirements are necessary, whatever registration's necessary, but to be able to earn my forgiveness from my sister and from my family and friends, and rebuild my friendship, my relationship with my family, so that I can continue to, my life's not going to be normal again, ever, but that I can continue to go into the world and do what I love to do, to help people, to help the community, continue to help St. Vincent de Paul, the Knights of Columbus, continue going to my church, continue altar serving in my parish, and just continue to be an outstanding member in the community, even with my actions.
Thank you, sir. Mr. Ziccarelli, is there anything else you'd like to add? You don't have to. I just want to make sure you've presented everything you want me to consider.
No, thank you. Nothing further, Your Honor.
All right, thank you. The State of Ohio, Blake.
Thank you, Your Honor. State certainly appreciates, Your Honor, the comments of Mr. Ziccarelli here today on behalf of his client, and Mr. Melenda's comments as well. I do want to say, Your Honor, regarding Mr. Melenda's home life and upbringing, a lot has been discussed about that, and the state doesn't discount any of that. The state does not take issue with what we've heard here today. But I do want to say that the state was probably aware of much of that before charges were even issued in this case. I think that a lot of the background is something that the state looked into. That was something that we certainly took into account with respect to the offer that was presented in this case. Similarly, with respect to sentencing recommendations that the state indicated to Mr. Ziccarelli that it would make, we indicated we would cap any prison term at 9 years. the background and the home life of Mr. Melendez is certainly something that played into those considerations. What the state is primarily focused on, Your Honor, is that the offenses at issue here, and I think the court will recall this from the facts of the change of plea, this was a course of conduct, a criminal course of conduct that went on for the entire 10 months that the Melendez family lived in Mentor-on-the-Lake. And the sexual contact, Judge, that's at issue here happened at least one time every month for those 10 months. That's how it was charged. But the reality is that the contact happened much, much more than that. And I think Mr. Melendez even essentially agreed as much in his pre-sentence report when he indicated this was sort of the bedtime or goodnight ritual. The conduct here, the criminal conduct, involved him preying upon his sister when she was in bed or getting ready for bed or having just woken up from sleep. And he would go into her bedroom at night and he would touch her breasts, her thighs, and her vaginal area. This was either when the parents were already in bed or not around. And although there's no evidence that this occurred simultaneously or together, I do think it is worth noting that Mr. Melendez's brother was doing almost the exact same thing, the identical thing, to their sister. And with respect to the victim, Your Honor, she is the defendant's sister. She is the defendant's minor sister. And as I think the court will recall from the change of plea, she does have cerebral palsy. So, as a result of that condition, her ability to resist these unwanted sexual advances was certainly impaired. She indicated a great deal of information to the state about the impairment of her muscle control and movement and things of that nature. So certainly she was in a vulnerable state when she was taken advantage of. While the victim's disability, Your Honor, is somewhat assumed within the offense itself, her age is not. And I think the court can take into account that she was 13 to 14 years of age at the time of the offense. Certainly, Your Honor, I think here the relationship also facilitated the criminal conduct. And quite frankly, Your Honor, you know, these offenses, they are, as I indicated, a course of conduct over the time that the family lived in Mentor-on-the-Lake. But as we know, it started even before that. This is conduct that went on for really 4+ years. Much of that conduct did occur when Mr. Melendez was a juvenile himself, but what was described, and when the family was living out of state. But what was described, the historical background of this, is that even sexual conduct, not just contact, took place out of state. The victim had disclosed to her parents, or her mom at least, in 2020 that this was happening, at which point, admittedly, the parents did not do much, but they did tell both Joseph and his brother Luke to stop this conduct. And it continued, quite frankly. So what we have here, Your Honor, is a victim who's had to live with this since she was 10 years of age. She is now 16 years of age, and even though the conduct has stopped because her brothers were incarcerated, she continues to feel like this is her fault. She continues to feel like her brothers are in this position, and her dad, quite frankly, who was also prosecuted because of her disclosure that she made upon an intake appointment at Crossroads here in Lake County. I will say, I agree with Mr. Ziccarelli. The victim has indicated to me that she does not agree with my recommendation for a prison term in this case, and I indicated I would note that to the court. With that said, though, Your Honor, I was very honest throughout with the victim that my considerations go beyond just certainly take into account her desires, but also there's a concern about protecting the public here as we move forward. And the behavior here speaks for itself. I will acknowledge I do think that the defendant in this case has been truthful throughout the pre-sentence report based on everything that the state is certainly at least aware of. The remorse issue is questionable for me. I do think he is sorry that this occurred. I do think, however, that the focus has been more on the life that he has lost rather than the harm to his sister. I do think that it is possible he has remorse, but at the same time, a lack of insight, even as he sits here today. And really, honestly, the entire family has sort of addressed it from that standpoint, that this is very sad for Joseph and Luke and the lives that they have lost. Well, but with that said, Your Honor, the state believes that prison is an appropriate sentence in this case. I will note that the state recommended, well, going into negotiations in this case, the state indicated to Mr. Ziccarelli that we would cap any prison recommendation at 9 years And that was a genuine or true cap, meaning the state was very much interested in learning what Mr. Melenda had to say for himself during the pre-sentence report process, very interested in learning more about him. The state recommended the full 9 years, or the 9-year cap, at Luke Melenda's sentencing. And again, that was for essentially identical conduct, very similar in nature. The state would note that Joseph Melenda appears to have been more truthful, more forthcoming, and more accepting of responsibility than his brother in the pre-sentence report process. And again, not that this is a contest or a comparison, but I do think it's fair to note that for the record. So here today, I would say to you that the state did indicate it would cap any prison recommendation at 9 years. While having recommended 9 years in Luke's case, he received a 7-year prison term. So the state would ask that you impose a prison term in this case for Joseph Melenda of not less than 7 years, but not more than 9 years. The state believes that that would be appropriate based on the conduct here in this case. The defendant does have credit, Your Honor, for 237 days of jail time credit. And just a word on consecutive sentences, the state believes that they are necessary here to protect the public and punish Mr. Melenda, and that they're not disproportionate to the seriousness of his conduct or the danger he poses. You know, Mr. Melenda himself disclosed during the pre-sentence report process that he went to Catholic Charities for counseling, and he was diagnosed at that time with a disorder I had never heard of. It was fracturistic disorder. And upon research, that's characterized by intense sexual arousal from rubbing oneself on non-consenting adults or non-consenting individuals in a public setting. So the state's very concerned about the threat to the public that Mr. Melenda still poses as he sits here today. And again, he wanted to work with a vulnerable population by going into the priesthood. 2 or more of these offenses were committed as conduct in which the harm was so great or unusual that no single prison term could adequately punish the conduct or reflect the seriousness. And although there is not a history of criminal convictions or juvenile adjudications, largely that's because this conduct was never reported. It happened. There is certainly a history of criminal conduct, and the state would suggest that that history of criminal conduct necessitates consecutive sentences, again, so as to protect the public and vulnerable populations in the future. And hopefully Mr. Melenda will take advantage of opportunities to seek the treatment and counseling that he has alluded to here in court today. So I'd ask that the court impose that prison term, Your Honor, with the appropriate credit. Thank you.
Thank you. Excuse me. This court has reviewed the pre-sentence report and investigation, psychological evaluation that was completed. I received correspondence from the defendant's mother. I have read and considered that. I have considered everything that's been said here in court today by Mr. Ziccarelli, the defendant himself, Ms. Blake on behalf of the state, recommendations from each side. I've considered the particular facts and circumstances of the offenses involved, the nature of these offenses. All of this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11 of the revised code. As for the factors in 29-29-12 indicating the conduct is more or less serious, the court notes that the defendant's relationship with the victim certainly facilitated the offense, that the victim suffered serious psychological harm as a result of the conduct involved, and that the injury experienced by the victim was exacerbated due to her age and her physical condition. There's no factors indicating the conduct is less serious. As for recidivism factors, the court does not find any factors are present indicating recidivism is more likely. Factors indicating recidivism is less likely. There's no prior delinquency adjudications. There's no prior convictions as an adult. The court cannot make a finding that the defendant led a law-abiding life for a significant number of years. This conduct took place over a significant number of years. Under 29-29-13b1, the court notes that the conduct or the convictions here that he's pled guilty to, the offenses for which he pled guilty to, I should say, are sex offenses. That overrides any presumption for community control. Prison is consistent with the purposes and principles of sentencing, and the court finds that it's not amenable to community control sanctions, and that prison certainly is warranted with the conduct here, the nature of the conduct, the period of time that this occurred. The number of times that this occurred certainly warrants a significant prison term. Therefore, it will be the sentence of this court that counts 2, 4, 6, 8, 10, 12, and amended 14. The defendant serve a term in prison of 12 months on each count. Court's going to order that counts 4, 6, 8, 10, 12, and amended 14 be served consecutive to each other, but concurrent to count 2 for an overall prison term of 6 years in prison. The defendant will be granted 237 days of credit. I need to advise you that upon your release from prison, you'll be placed on post-release control for 5 years. It's mandatory in this case. While in post-release control, if you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of the prison term imposed by the court. Any additional prison term imposed for violating your post-release control is being imposed as a part of the sentence at this time. You're going to be ordered to pay all costs incurred in this action. Court will dismiss the balance of the indictment as agreed to. Court further finds that consecutive service is necessary in this case to protect the public from future crime and to punish the offender, that the consecutive terms are not disproportionate to the seriousness of the offender's conduct and to the danger that he poses to the public. And the court finds that at least 2 of the multiple offenses were committed as a part of 1 or more courses of conduct, and that the harm caused by these multiple offenses was so great or unusual that no single prison term for any of the offenses committed as a part of the courses of conduct adequately reflect the seriousness of the defendant's conduct.
Today's hearing shocked everyone. The defendant admitted a serious offense, and both sides presented their arguments. After reviewing the reports and statements, the judge announced a strong 6-year sentence in open court. What do you think? Did the judge make the right decision? Share your thoughts in the comments.